So let's get going. So my name is Francoise Gilbert, and I'm a lawyer. I practice at the law firm Greenberg Tuareg. We are the third largest law firm in the country. We have 2,000 lawyers, and we have a presence in 38 different. We have 38 different offices, 10 of them around the world. I work on data all day long, but as a lawyer, not as a software engineer. And my particular interest is on global issues, and the big red thing is a book I have written and I keep up to date that covers the privacy laws of 68 different countries. So I try to keep up with the world. So let's talk about why we are here, or why I think I'm here, is to talk about the legal issues surrounding the world of big data. And when I think of big data as one of you, as a software engineer, as a whatever, a designer, a creator, someone with an analytical mind, I get very excited because there is a lot to do, there is a lot to discover, there are a lot of inferences to create. So it's a very exciting world. And for you, I think it's probably something new. It's something, well, that has evolved over the years, but that in the recent years has really exploded. And so it's very exciting. But it's new from your standpoint. It's not necessarily new from the legal standpoint. And what I want to stress to you is that there is a certain framework within which we have to fit your wonderful work in sometimes very old laws. And the creations, the reports that you create are used or could be used for a number of purposes. And some of these purposes are great and will be approved by society as a whole, but some of these purposes may not be that great, and actually we have laws about that. And one of the most important laws is the Fair Credit Reporting Act. The Fair Credit Reporting Act is a very broad law that has to do, in general, with the relationship between your credit report. Hopefully you all know what a credit report is. It's something that's put together by a number of organizations, and that is used for a very significant number of purposes. For example, if you want to lease a car, they're going to ask you for your credit report. If you rent an apartment, if you apply for a mortgage, these are very important documents that have a very significant role in whether or not you can get the car, or you can get the apartment, or you can get the mortgage. So that's what the Fair Credit Reporting Act does. And there is a restriction on the uses of these credit reports. And so it has to do with the use of this information to determine the eligibility of people for credit, employment, insurance, or housing. And so those companies that use these credit reports for that purpose, they are highly regulated. And so it's not just like anybody who can just pull out a credit report and make decisions about that. You have to respect certain laws. And so one of the main uses of your big data reports, unfortunately, could find their ways into being deemed a credit report that companies use for making determinations for employment, insurance, housing, and credit. And that becomes illegal. And we have a case right now, actually, the Supreme Court made a final decision just on Monday. It's a case against Spokeo. I'm sure you all know of Spokeo. And Spokeo got in trouble because it was advertising that people could use its service to make employment decisions, and that's a big no-no. And so there was a lawsuit, and that went up to the Supreme Court. So watch out when you do your work, that the work may be used for those purposes, and that would be an illegal purpose. So you should at least alert the organization who is asking for that. And going even broader than this is another set of laws that we have in the US that not just focus on employment or credit, but that focus on discrimination in general. And there are a number of laws which go under the umbrella of equal opportunity laws. So there are a number of them, and they are listed here. And the goal, again, of these laws is to prevent discrimination against people for many reasons, for their age, their sex, their religion, their age. And the intent of the law is to protect people from being discriminated against. And so when your reports may be used for those purposes, again, the report is used for illegal purpose, and so you need to, again, make sure that you stop that, you prevent that, you alert whoever is asking you to do that, because you would be aiding in an illegal purpose. So these are the two major sets of laws that I wanted to alert you about. But then there is something even more broader than that. It's the Section 5 of the Ftc Act. And what the Section 5 of the Ftc Act does is simply prohibit unfair and deceptive practices. And you can see how this can be interpreted in zillion ways. And if you pay a little bit of attention to the world of privacy and cybersecurity, you will know that the Federal Trade Commission has been very active in prosecuting a significant number of companies now for their activities that the Federal Trade Commission determined to be either unfair or deceptive. And that can be in so many different ways. For example, one of the companies listed here is Path. And Path is a provider, they have an app. And the app was collecting all of the customers' phone address. Just as you were downloading the app, the first thing the app was doing was collecting all of your contact information, but didn't tell you. And so that was deemed to be a deceptive practice because they would not tell that to the customer, and on and on. And so when you look now at what that means in your world, in the world of big data, what big data or analytics starts with is the collection of a large amount of information. And so where does that collection of a large amount of information fit within the constraints of the Section 5 of the Ftc Act? Because the Section 5 creates an obligation to let people know that something is happening. And if you don't tell them that something is happening, it becomes illegal. And so when the data are used for your big analytics project, maybe this use of the data is also an unfair and deceptive practice. So what you need to look at is whether the company failed to disclose information to its customers and other elements. And I'll go through more of those later in this presentation. So we have Section 5 of the Ftc Act, which is a huge, very significant piece of law, but we have much more. And so it's not just that you have to worry about what I just told you, but we have all of these here. So if you do any work related to the healthcare industry, for example, you have to be careful that there is a law called HIPAA. And that's the federal law. Then we have state laws that also govern the use of information that contains healthcare information. You have Gramm-Leach-Bliley and a number of other laws that deal with the handling of financial information or credit card report information and so on. And then, of course, you have the state laws. So again, many important layers of information. So you should, don't want to scare you, but you're kind of walking in a minefield, and you have to know how to navigate, because the laws that could restrict what you do or what the uses of the reports you create could be very significant. So who enforces these laws? Again, I talked about the minefield. Now I'm going to get to the machine gun, because one of the chief enforcer is the Federal Trade Commission. So they operate at the federal level, and they have a very broad jurisdiction about many companies. So to give you examples of companies that have been investigated and spanked by the Federal Trade Commission, just companies around here, to name a few: Google, Facebook, Twitter, Snapchat, and many others. So that's the Federal Trade Commission. Now you also have other agencies, for example, the Federal Communications Commissions, the FCC, who is getting into this area as well, and has issued a number of judgments recently against Verizon, against AT&T, for practices that were too loose in connection with the collection or protection of personal information. And then we have others. We have the SEC, the Security and Exchange Commission. We have the HHS, that has to do with protection of healthcare. And statewide, we also have the State Attorney General, who are very active, and sometimes have actions on their own. Sometimes they have actions as a group of State Attorney Generals. Sometimes it's grouped, the state AGs and the Federal Trade Commission. So definitely a significant amount of enforcers. I told you I love international law, so I have to have a slide on that particular aspect. So what does the world look like? You think that America is bad? Well, you should look at the others. So first, Europe. Europe is a region that is very highly regulated. And anything that has to do with discrimination, anything that has to do with profiling, anything that has to do with monitoring is not accepted, very highly regulated. That also becomes even more evident in the upcoming law that is going to change the data protection regime in Europe. You should be aware of it, because it is now official. It was voted a couple of days ago, and that law, called the European General Data Protection Regulation, or GDPR, becomes effective in 2 years, May 25, 2018. And that law not only keeps the already existing restrictions in many areas, but increases the protection of individuals and the obligations of companies, and in particular has numerous provisions that address directly big data. So throughout the law, there are obligations that are increased obligations as compared to the general use of data. Occasionally you have, well, if you do what I would translate as, if you do work in the big data area, you need one more of these or one more of that, and that can be obtaining specific permission to do the work, to having very detailed paperwork, to doing a privacy impact assessment or a security impact assessment. So a lot of obligations and restrictions. Asia is a little bit behind Europe in some ways, but don't get fooled by generalizations. For example, South Korea is extremely strict. It's even stricter than what we see in Europe. So be careful where you are acting in Asia. And the group of Australia, New Zealand, Hong Kong, very much influenced by British law. That means very much influenced by European law, and again, they have a number of restrictions. Africa, Middle East, not too much right now, but it's getting there, and we have a number of countries that enact data protection laws in particular, and these laws mimic what is happening in Europe, so the European influence is basically throughout the world, other than the US. And for some reason, I don't know, I forgot Latin America on this slide, but Latin America is also very active. We have a number of countries that have adopted general data protection laws very similar to what we see in Europe. So again, with a lot of restrictions. So I cannot summarize the world in 20 minutes, but I wanted to show you what the world thinks about privacy and information practices, because that is, other than the anti-discrimination laws that I described earlier, this is a very important basis on which your work has to take into account. So on this slide, you have what we call the Fair Information Practices Principles. And if you want, it's like the 10 Commandments. It's very high-level concepts that you can find in almost every single data protection law and privacy law in the world. And so I use that because it helps you find a very simple framework. There was a young lady earlier who said, give me just a few words that I have to remember. Well, if you don't remember anything, try to remember this particular slide because it summarizes a number of your obligations. So I'm going to go through some of these in the next slide. One of the most important principles is notice. So when something happens, when your company collects my data, they have to tell me what they are doing. And the typical information that is expected to be given in a notice is what information is collected, how it's used, who gets access to it, and also what kind of rights the user, the individual person, the data subject has, and so on. And so you can see how this notice can be important in the big data context, because currently most of the notices that are published don't really say clearly whatever data you're going to give us, we're going to put that in a big pot and stir it with all sorts of other data and come up with conclusions. That is not there. And that makes a big difference, because it's one thing for me to give you my name and my address. It's another thing to know that all of a sudden now you have put me in the category of people who live in ABC area and therefore have that socio profile, that type of income and so on. This is not what I registered for when I registered to get my cooking app. So very, very important in the big data context. The other part is the consent. So you notify me, but now I have to agree. And I have to be able to choose, and to choose also to walk away and say, no, I don't want you to do this. And so that's often I use example that you can relate to, because these are disclosures that you see on websites. That's often the notion that the person is giving consent is often at the very top of most privacy policies. And basically it says, for example, here on the top one, when you use the service, you also consent to the collection, transfer, manipulation, storage, disclosure, and other uses of your information. That's where the consent comes. But remember that consent should also have a meaning. And this is a consent today, now, because I go on the site for the first time. But what happens if you change? If you change your practices? If you do something that last year you didn't tell me you were doing, and then all of a sudden now, it started with a nice, happy website with nothing, and then 1 year later you change. Well, you should tell me, the customer. You should inform me. that this is changing, and I should have the opportunity to say, stop, I don't want to be there anymore. So that's where the notion of choice comes up, and that's a very, very important component, the ability for the user to get out, for the individual to get out of the pool. Another principle that is very frequently found in most data protection laws is the notion that you should collect only what is necessary. And you see the contradiction between collecting only what is necessary and then your objectives as data engineers of having as much as you can so that you can cut and parse and organize to find whatever correlation and inferences you want to find. So a difficult situation here where we as a society need to make a decision on what is acceptable or not. And in particular, I want to bring your attention to this particular slide. The example I used was location information. This is a very sensitive area. And if you pay attention as just an iPhone or a portable phone user, very frequently when you open an app, you have a request to collect your location information. And that's because location information has been recognized now, both here and throughout the world, as being a very sensitive information. Because if you know my location throughout the day, you know who I am, you know where I am, you know where I live, you know where I go to lunch, and you can establish a very, very clear profile of who I am. And so that's an example of something where society has decided we should be careful on the collection of location information. And there was a case actually filed by the Federal Trade Commission on exactly that particular issue, where you had a company that was offering a flashlight app. It was before the iPhone had the nice flashlight incorporated. And so you would download the app, but the app was not just used to give you the light. It was also used to collect your location information. But that was not said. In the disclosures, the users never had an opportunity to say, well, that's okay, you can figure out where I am. I need the torch right now. So that went again was investigated by the Federal Trade Commission, and the company now is under a 20-year consent decree with the Federal Trade Commission. So pretty serious. Another principle that is very common in the privacy and security world is the limitation on the use, the disclosure, and the retention of information. And that, too, is a horrible thing for data engineers, because you want exactly the opposite. You want to do any kind of use, any kind of disclosure, and keep that stuff for as long as we want. So it's a dilemma. I'm not telling you what to do. I'm just telling you this is my world, and I know that your world is different. And we need, again, as a society, to make a decision as to what can be done in what circumstances and for what purpose. Another principle that I mentioned earlier is the right for people to have access to their information. And this is something that is very much universal. It's not totally widespread in the US, but it's getting there. We have that in particular in connection with credit information, for example. You have a right of access. Health information gives you a right of access. And many companies that operate on a global basis are required to do that in other countries and offer that also in the US. Here, this is an example of Twitter, and that's the section related to your right to have access to your information. When you are in a big data environment, you can imagine how difficult that could be. I have a client right now with whom I'm working, and her issue is not really big data. Her issue is that she has received a request from the Department of Homeland Security for having access to certain data about one of her customers. And the data is everywhere. And she says, if I have to respond to their question, it's going to take me 10 engineers and a month to grab every piece that they want. And what do I do with that? So we're negotiating with Homeland DHS to make it work for both. But in your situation, you could find yourself exactly in that same situation where you have this huge data bank, and then for some reason, some entity has the right to have access to that, whether it's an individual or whether it's a government agency. What do you do? How do you handle the particular situation? And all of that is actually connected with this particular principle, which is the principle of accountability, meaning that you are responsible for the data in your custody. So what does that mean? That means that you have to be careful to whom you give it. And that goes back to my very early slides when I said, be careful, there are things that are illegal. And if you have your report and you know that the report is going to be used for things that are illegal, now you have to be careful not to become an accomplice to this illegality. And that's tied to this concept of accountability. So accountability is broader. And it has to do with your relationship with a number of entities, whether it's your service providers, your business partners, or in the big data case in particular, the clients who are asking you to do certain things. And so going back to what I was telling you earlier related to the international situations, it becomes very, very complicated when that involves data of foreign origin, because there are even more restrictions. And that reminds me, by the way, that I told you earlier that Europe has just adopted. Am I already out of time?
No, ma'am, 10 minutes.
10 minutes, okay. That Europe has adopted the General Data Protection Regulation, and I have in the back of the room a summary of it, and then so you can help yourself, and then I'll bring the remainder upstairs in the sponsors room so that everybody can take a copy of this article. Okay, continuing, for my last 10 minutes, one of the last principles is the principle of providing security. It's obvious you have data that could be very sensitive, and so you have to protect it. And I'm sure someone is going to tell me, oh, well, that doesn't apply because most of the data I have is anonymous. And I hope that at least people of your caliber and your experience and your knowledge know that there is very little that is anonymous anymore because of the big databases. So don't give me that excuse. Think about security anyway. So security is complicated, but that's one of the areas where there is a lot of guidance, a lot of rules, and companies can find guidance in many documents. Those that are often used is the ISO standards, but there are more, and I'm happy to give you even more guidance on that. So to conclude on this part, you see that there is a very significant disconnect with the needs of the big data and the analytics community and the legal structures that are in place that have been created to protect people's privacy, people's rights, people's ability to find a job, people's ability to freedom from discrimination and so on. So it's a difficult situation, and we need to work around that. We've talked here. We have a summary of the the big hazards of big data, the indiscriminate collection of data, the profiling possibilities, and the errors that can be done. They are always. I know you guys are perfect and you have the best intentions, but sometimes you make errors. Occasionally. My favorite one was one of the very early examples of big data was look at Google. Google was able to predict the flu, and Google was predicting the flu based on the research, the keywords used in the research, and then so that was very exciting. Look, all of this emphasis on searches for the flu, and then 2 weeks later, half of the country has the flu. That's it. Big data is the savior. We're going to avoid flu epidemics. And then after thinking a little bit more, they found out that, well, but that does not apply necessarily, because you can have the flu in Asia and the Europeans be concerned because they are paranoid and they say, oh my God, all these people who travel, we're going to get the flu, so what should we do? And that doesn't mean that they are going to catch it. And other twist that makes that the data was not that reliable. So there can be errors. So what does society do right now in this connection? I want to bring you some guidance or some attempts at guidance. One comes from the White House. The White House has been very interested in big data. And so in 2014 and 2015 has produced a number of reports. They are pretty thick, but quite interesting to read. Same thing at the level of the Federal Trade Commission. The Federal Trade Commission has produced preliminary reports and then a final report in January of 2016. The FTC report outlines dangers, and we have talked about some of them. Some of these dangers. Another source that could be of very important interest to you is the Data Science Association that has a code of professional conduct. And in particular, if you look at rule number 8, you have a number of the items that I have discussed earlier about what you can do to avoid or reduce the mistakes or the errors or the discrimination. Evaluate the quality of the data, taking reasonable measures to protect the clients from decision based on weak evidence, and so on. I'm not going to read the list. You will have a copy. You can refer back to it. But I think it's a good list of things to think about to make sure that the work you do is ethical and for a good purpose. And also things to think about. Policy consideration, so it's another way to translate the code of conduct. How, and to question also what you do. How accurate is the data I've been using, and am I jumping to conclusion here or there? That also should be helpful. And finally, the last two slides are providing you a checklist. So that's a summary of what we've seen. And how to translate the legal principles that are unavoidable because they are there into day-to-day decisions that you can make in your work. So there are two checklists, one here and then the second is here, and you can keep that. And on this happy note, I will just stop here, and hopefully we can have a discussion, and there are questions.
Thank you for the presentation. Given that many sets of disclosures and other consent agreements are quite long, how do you get users and just people in general to read them? Serious question.
These disclosures are really not for users. They are more for lawyers or for government organizations or for litigants. We have to make them, because if we don't make them, we get slapped, including because of the laws that are mentioned. So what we do to communicate with the real people is often we have summaries. So when I do my work, when I work on these disclosures, that's something I do on a regular basis, we have the long version, but we also have the 5-line summary or 7-line summary that give them a little bit of the cliff notes of what is happening. So that's one way to communicate. Another way to communicate is to it's called just-in-time disclosure. So when you disclose, when you're going to do something, you're collecting information, adding a small sentence. This information is going to be used for this purpose, and that's also a way to bring attention to them. So it's not easy, but that's one piece of work that I love doing with people like you and the marketing folks and so on. It's how to communicate our world, which is regulated, and as I said, if we don't do it, our clients get in trouble. And then the reality of making sure that, to the extent possible, users are informed of what is happening. But it's not easy, and often, I fight in particular with the marketing people, because you're taking my real estate, and I need every single piece of that screen. But we end up agreeing. But as you know, it's a place where you guys can be creative and give us give us more suggestions. I see a question there.
One of your slides, you had consent and choice as a requirement for gathering data. Mm-hmm. Does it apply to recording conversations without consent?
Ooh, this is a huge one. Okay, the notion of consent applies to many situations. And so it goes, when you have a website and you want to have you're collecting information on the website, or when you have an app and you're collecting information on the app. The recording of a telephone conversation is one of the most highly regulated activity, I would say. It has its own laws. And so to simplify as much as I can, there are about 10 states where it is required to obtain the consent of both parties to the conversation. So if you call me and I'm going to record you, or the conversation, or I am an employee. I'm an employee of Neiman Marcus, and then you're going to call me. Neiman Marcus has to make sure that I know, as an employee, that my conversation is recorded, and that you, as the customer calling me, know that the conversation is recorded. And so that's why when you call whatever, the call center at PG&E because your gas bill is too high, they say this call may be recorded for training purposes and so on. So they are required to do that, in particular in California. California is a state that requires permission on both sides.
The reason I'm asking is I'm aware of 7 states, including Texas, where there is no requirement for notification.
Yeah, there are states where there is only one-way notification.
Right.
Yeah.
How would that violate the federal requirement of notification?
Let's bring the mic to the question. Oh, no, he spoke on the mic. Okay, anyway, I think we're running out of time, so we're going to wrap up. Let's thank our speaker once more.
Thank you.
And conversation is welcome after the talk, and there is a handout, and in the next talk.